Thank you. Please be seated. This is the time set for oral argument in 1 CACV 18-0091 Becker versus Summit. Counsel, each side is allowed 20 minutes for argument. The appellant may reserve a portion of that time for rebuttal. If you wish to do so, counsel, please keep track of the time on the podium clock and keep track of that time for yourself. We won't be keeping track of the time for your rebuttal if you have any. Out of respect for counsel and the court, I ask that those in attendance please make sure their cell phones are off or on vibrate. Counsel, we have read the briefs. We have conferenced this case just this morning. We encourage you to keep that in mind when you make your arguments to us this morning. Proceedings are being recorded. They'll be uploaded and posted to YouTube. So before you make your argument, please state your name and the party you represent. With that, Mr. Feltus, go ahead.
Thank you, Your Honor, and I'm going to endeavor to reserve 5 minutes for rebuttal, and I understand I'll keep track of that time. Your Honors, my name is Todd Feltus. I'm with Kirschmar & Feltus, and I'm here on behalf of the appellant, Becker Board Summit, LLC. And may it please the Court, Becker Board Summit is here seeking appellate relief because it invested $1.3 million in wall sign advertising at the Summit at Copper Square condominium. That investment was rendered worthless by the trial court's ruling granting summary judgment stating that it had no property right. The trial court erred in making that decision, and it erred in making that decision for 3 basic reasons. First, there was a property right. The declarant to the condominium, Urban Commons, properly reserved development rights that it had, and on those development rights it had the right to create limited common elements, it had the right to allocate those limited common elements, and it followed the proper steps to do so. Second, as the owner of Unit 1708, which Urban Commons assigned that limited common element to, it had the right of exclusive use. And with the right of exclusive use, it had a right to grant an easement to Becker Board Summit to use the walls. Third, there was no agreement at issue here between Urban Commons, the declarant, and the association that could be invalidated under 33-1245. And for those 3 reasons, Becker Board Summit had a proper easement right to use the garage level exterior walls for wall sign advertising.
Can you pause for a second on that third prong?
Sure.
There's no agreement between the association and Becker Board Summit. That's your argument? Is that what you said? I'm sorry.
That's a correct statement. There was no agreement between the association and Urban Commons, the declarant, that would be subject to cancellation.
The agreement granting the easement between the association and Urban Commons, the first easement, and then there was a second agreement that went from Urban Commons to Becker Boards, right?
Correct.
Okay. Why isn't that first agreement a contract that is subject to invalidation under the statute?
Let me attack that question 2 ways. One, Urban Commons, as part of one of the development rights that they had, was the right to create an easement. It could do that unilaterally. So it really should have been done as a Third Amendment to the Declaration, granting the easement. The mere fact that they structured it in a form that was a grant from the association to Urban Commons, is essentially a form over substance argument. And if you take a look at 32-1213D, where you have insubstantial errors, it shouldn't affect title to the property. So I guess that would be the first point. If you changed the title of the easement to Third Amendment to the Declaration, there'd be no question that this was a proper exercise of Urban Commons development rights. So that's I guess the grounds for invalidating or for not applying 33-1245. But even if you go to that point and say, it was really an agreement and it's subject to that, I think the court could invalidate that easement and not affect the transaction because you go back to the first two amendments to the Declaration that Urban Commons executed, and they exercised that well, really not pursuant to the development rights, but pursuant to the rights to allocate a limited common element under Section 2.8.4 of the Declaration, and it's permitted under ARS 32-1218. The first declaration allocated the first amendment allocated a limited common element for the third and fourth floor of the garage level walls and allocated that limited common element to Unit 1708. The second, that was done in 2012. A year later, the second amendment to the declaration allocated the fifth floor of the garage level walls to Unit 1708. So, I'm sorry.
Just maybe back up just a bit.
Sure.
Give it, sort of help me with a little bit more fundamental understanding of how you're viewing the common elements. It seems like your argument is the declarant had the right to take any portion of the common element and redesignate that or reclassify, whatever, create through a limited common element.
Yeah.
Of that portion. Let me give you an example. The parking lot. Is there a parking garage? Yeah, there's obviously parking spaces.
Right, that's what we're arguing about.
No, but the inside, the actual parking spaces, could you have taken a number of those parking spaces and reassign those to just the developer to just be part of that unit? Like take 50% of them. Taken 50% of those parking spaces.
Yeah, no, let me get at it a long-winded way on the parking. The parking lot spaces were designated as a limited common element and were assigned
Initially,
to.
so they're not common elements.
Well, common.
Explain to me what a limited common element is.
Yeah.
Isn't it part and parcel of a common element?
I think that if you have Venn circles, you have common element as the big circle and a limited common elements within
all
that.
All dogs are collies. All collies are dogs, but not all dogs are collies.
Exactly. Thanks for a better analogy.
My question is, what would have been off limits then? What couldn't you have done? I mean, is the top of the roof, is the rooftop, is that a common element?
Yes. Everything that's not a unit
And
is a common element.
It's not a limited common element. The whole top of the rooftop.
I'd have to go back and look. I don't believe that it is.
But for argument's sake, could you take it and use it for a different use? I mean, put a billboard up on the top of the building, assuming it's allowed by zoning.
My read looking at it just under the lens of the Condo Act, yeah. If the top of the roof was a common element, the declarant, because they have the right under 2.8.4 of the Declaration, and they've reserved the development right, they would have the right to allocates what the statute uses, the common element as a limited common element.
I know I'm jumping around.
Yeah.
But how could the declarant do that without offending the principle that you would be taking away something from all the unit owners who essentially owned a proportionate share of the rooftop?
I guess
when they bought the condo.
Yeah, no, I understand your question. I guess where I take issue with the premise that really where the association's coming from is that the unit holders had, an unequivocal, fully vested fee simple interest in the common elements. They didn't.
What's wrong with that? What's wrong with that? Yeah.
I mean, conceptually it makes sense, and from my standpoint, looking at it from an optics standpoint, it's kind of the hardest part of explaining this argument. But when you have, you go back to the origins of the Condo Act. They're trying to solve the problem. How do we give developers more flexibility in these projects? And the way they came up with it was development rights. And so they allowed the developer, take your rooftop example. They could have turned that into a unit. They could convert that from a common element to a unit. They could do that. That's in the declaration, and that's where the notice goes to the property owners. So when you're buying into a condo that has development rights that have been properly reserved, you're essentially getting a contingent interest in those common elements, subject to the declarant's option to convert the common elements. They could convert it to a unit. They could create an easement over it. They could allocate a limited common element.
Or unallocate a limited common. They could take a limited common element and go the other way, or not?
That they can't do. Once that limited common element has been allocated to a unit, then they can't reverse it, at least not without the consent of the unit holders who have the exclusive use to that limited common element.
Doesn't the statute also kind of restrain the developer in some way in the non-discrimination provisions. And I know your argument is that there's a distinction between a common element and a limited common element, and the common elements are the only things that you can't discriminate in favor of yourself on, correct?
1217 basically says that you can't discriminate on the common element allocation. So when they did this,
Isn't it a bridge too far to say, okay, we'll avoid the non-discrimination by just calling anything that's a common element a limited common element?
I don't think that's a bridge too far, because I think where the trial court erred is they conflated the allocation under 1217 with the specific right under 1218 that allows the declarant to do just that, to allocate a limited common element if they reserve it in the declaration.
Now I'm going to hang you with the analogy that you liked earlier. And I didn't plan this, but
No.
if all collies are dogs,
Yes.
and there's a provision that says you can't discriminate in the allocation of dogs, you can't discriminate in the allocation of collies either.
The verb allocation is used two different ways in section 1217 and 1218. In 1217, the verb allocate is giving a percentage interest to all the various unit holders within the condominium project. I mean, that's what the plain language of the statute says.
But didn't you give 100% of the exterior walls to 12 or 1708?
Just the use, not the ownership. The ownership stays the same. The only thing that gets
Easement is the ownership, isn't it?
no, the ownership is the ownership, and condos work a little differently than other pieces of property, which is I think what we all are getting a little confused by on these different terms. The ownership of the common elements remains the same, and if you have 100 units and it's allocated 1% for everyone, even if you allocate the roof to unit 100, everyone still owns 1% even of that limited common element, because it's all part of the common elements. Now, the ownership does not change by the allocation of the limited common element. All the limited common element does, and it's by definition in the statute and in the declaration, all the limited common element does is grant a right of exclusive use to one or more, but not all of the unit holders. So allocation in 1217 talks about how we're going to divvy up the ownership right. And where the discrimination comes into play is that the owner could take a lesser share of that allocation and they wouldn't have to pay as much in expenses. That's where the concern is on discrimination. The allocation's used differently in 1218 because we're not allocating a percentage of ownership in the condo units. What we're doing is saying this space, this parking space, this patio, this storage closet, if we're going to do a two-phase condo project, we're going to reserve phase one of the pool, the phase one pool for the phase one owners, or the garage level signs here in this case. We're going to allocate that space to a particular unit, but it doesn't change at all the 1217 allocations.
Okay.
And I think we tried to lay that out in a footnote in our brief, talking about how the trial court conflated. It's using the same verb, but it's using a different definition of that verb allocate. So we've talked about touched on limited common elements, and hopefully I've covered all of that. I mean, the limited common element's not ownership. I mean, it's exclusive use. So again, there isn't anything with the discrimination of the ownership. It's just a right to use. I mean, it's I guess a way to look at it would be almost like a leasehold interest. And when you have that exclusive use,
but leasehold is
it's
a
different.
form of ownership. I mean, all these things. That's why I'm confused, because you said granting the easement is not granting ownership. It's ownership of something, whether it's the right to use that or the thing itself. Help me understand the distinction you're trying to make there.
Well, when you have an easement, you don't actually have a possessory interest in the property. What you have is a right to use it for a limited purpose. I mean, it's
a property right.
It's most definitely a property right.
I mean, it could be possessory, and it depends on what
driving across the easement.
I mean, I'm possessing it while I'm driving on it, or if I have the right to eat on it, have a picnic on it. I mean,
I I agree with everything you're saying, but that's not what the cases are saying.
What's the significance of the word possessory?
It means that you have the ownership, that you have something else than just permission to use it.
Well, an easement gives you title, an aspect of title.
I don't believe that it does. If you're following what the restatement's saying and what Arizona cases are saying on it, I don't believe it goes to that point.
It's not
a form of title.
Okay.
It's a property right.
Okay.
And I think that's where we've all gotten a little bit confused here, because there wasn't a conveyance of the common element itself. What was being conveyed was the right to use the limited common element
In perpetuity.
but that's how easements work.
Back to the parking example, if the parking space is a common element, could they then say, you still own this common element, but we're granting someone else the exclusive right to use it, and that would be okay?
If the parking space started out as a common element, and me living at the condo, I was parking there every day, and then the developer came in and said, sorry, I'm allocating this as a limited common element to 300, you're going to have to park in another spot. That's permissible.
And they could take 100% of the spots and say, you don't have any parking rights down there anymore.
If I had the limited common element, they couldn't do that. If they were just a free-for-all for the use of everyone in the building, under the Condo Act, they could. I mean, I think we could get into a scenario under common law or the contractual rights that the owner may have and might have a problem. But under the Condo Act, as long as the declarant owned a unit, they could unilaterally allocate that as a limited common element. And, Your Honor, I want to save a few minutes for rebuttal, so I'm going to yield, I guess.
Any other questions?
No.
Thank you, counsel.
Thank you.
May it please the Court, Curtis Eckmark on behalf of the appellee respondent, Summit at Copper Square Condominium Association. Every purchaser in a condominium obtains a property interest not only in the unit that they purchased, but in the common elements as well. In this case, those walls were originally part of the common elements. So everyone who purchased there had a property right not only with respect to their unit, but in those common element exterior walls as well. Today, Becker stands before the court and says that they have the exclusive and permanent right to use that property. That begs the question of how the association members lost that right. How did they lose that right without a vote? And how did they lose that right without any type of compensation to them? Now, if Becker claims that they rely on a contract to do that, then that is voidable under ARS 33-1245. If they claim that they rely on any type of conveyance, transfer, or encumbrance, that is void under ARS 33-1252. So the only way that Becker can prevail today is to convince this court that it somehow magically obtained a permanent, exclusive property right without any type of contract, conveyance, encumbrance, or transfer. And that's just simply not possible. The first statute is 1245. And what the Act does is it recognizes three distinct phases of any association. There's creation, there's the period of declarant control, and then there's the period where the owners control their own destiny. And what the Act does is it sets forth certain checks and balances, and that's exactly what 1245 is. It's a check on the declarant's power. Because yes, the declarant in creation has incredibly broad rights with respect to development rights and other things. But the entire purpose of 1245 is to recognize the danger in that absolute control of the association and allow the association to get out of any long-term agreements that the declarant attempts to bind the association to that last beyond that period. And that's exactly what we have here. In order to protect the association, the statute renders voidable three specific types of contracts. One, those between the declarant and the association. Two, contracts that are unconscionable. And three, contracts that are not bona fide. In this case, we have all three. The first is that set of amendments. Arizona law has recognized that CC&Rs are contracts. That's been the law for 30 years. Becker claims the association's not a party to that. If that were true, then they can't bind us to those amendments. We have to be a party or else we wouldn't be bound by them. And if we are a party to those contracts, then 1245 applies. The real key document, as you hit upon, Your Honor, is that assignment. That is the one that was signed by the same guy, by the way. The same guy signed it on behalf of the association and the declarant. So that's the classic case that 1245 is meant to protect against.
Counsel, that's the, you help me, that's the first easement.
Correct.
Or amendment, or whatever it's called.
Absolutely, Your Honor. Well, there were two. There were amendments, and then there were easements.
Okay, first easement.
And it's the first easement, and that's the one between the contract and the declarant. Now, what happened is at the trial court, Becker argued that those weren't contracts, they were conveyances. And then they ran into 1252, as I mentioned, and now in their motion for a new trial, they made the brand new argument that, oh, even though we drafted these documents, we're now claiming that that document wasn't necessary. The trial court properly ruled that that argument was waived. But even if it's not waived, all you have to do is look at the transaction to see how necessary that document is. The two easements, when you look at them together, the second one does nothing more than assign whatever rights were granted in the first. So if the first goes away pursuant to 1245, there's nothing to assign in the second document. Also, if you take those easement agreements away, what are we left with? We're left with the allocations of limited common element. What would that mean? That would mean that the owner of 1708 would have the exclusive right to use that property. Well, that's fine, because Becker doesn't own 1708. They never have, they never will. The association owns it today. The reason Becker had to do those assignments was they have to have a right to operate a commercial enterprise from association property. That's what those easement agreements do. That's why they had to do those easement agreements, because without those, they have no right to use association property to operate a commercial enterprise. And so when those easement agreements go away, Becker no longer has any right to use the association property to operate a commercial enterprise. The third violation of the statute is procedural unconscionability. The legislature used the word unconscionable, even though Arizona law for years has recognized both procedural and substantive unconscionability. If the legislature meant to exclude one of those, they certainly would have said so. In this case, what Becker could have done and should have done is exactly what their own title company told them to do. They could have gotten a vote of the owners. That's what the Act requires. That's what the documents require. And at a minimum, they could have gotten a committee of owners to approve this. But of course, that would have never happened, because what owner would ever approve a transaction in which the association loses all of their rights and gets nothing in return? And that segues into the fourth violation of the statute, is substantive unconscionability. And that is the test. You look at it from the homeowner's perspective. From the homeowner's perspective in this case, they lost all rights to their walls forever. In return, they got nothing. I mean, it couldn't possibly be more unfair, and even Mark Becker himself admitted that it was unfair. Now, the fifth way that it violates 1245 is this whole transaction was not bona fide in several respects. First of all, if you're going to buy property, you go negotiate with the people who own the property. You don't negotiate it with someone who's already sold it to the people who own the property. They did that because their own appraisal shows that they paid pennies on the dollar by going around the association and negotiating with the declarant. Also, in a bona fide transaction, you don't have the same guy signing the deal on behalf of both parties. And the last two reasons are the most significant in terms of bona fide issue. This was not and never was a bona fide allocation of a limited common element. Because in order for any property to qualify as a limited common element, a property owner, a unit owner, has to have the right to use that property. Look at what happened in this case. So a typical one...
Does that come out of the Condominium Act?
That comes out of the Condominium Act, and it comes out of the documents themselves. Both say that a limited common element is for the exclusive use of one or more owners, not third parties, not commercial entities, owners. So there has to be an owner. And you mentioned parking, the court mentioned parking earlier. It's a perfect example of how this should work. In the plat and the declaration, the declarant reserves the right to have a parking garage. They label it a common element. And then in the CC&Rs, what they do is say, okay, we are reserving the development right to allocate parking spaces as we sell units. So as I buy a unit, that parking space gets allocated to me. As you buy a unit, it gets allocated to you, and so on down the line. And that
Or it becomes a limited common
correct.
element?
That's exactly how it should work. The parking garage, which started out as a common element, gets allocated to the unit owners. Each space becomes a limited common element. Another example would be balconies or patios. Those get allocated to individual unit owners, but they're allocated on an equal basis to the unit owners, not, as Your Honor mentioned out, on an exclusive basis to, one unit. That violates 1217. And then, but contrast that to what happened in this case. In this case, the property allocated was 17 stories away from the unit. Then it had nothing to do with that unit. There was never any intention for the unit owner of 1708 to use that property. There was never any intention for any unit owner to use that property. The sole purpose of that allocation was to pave the way so that the developer could sell that property to a third party.
Do you acknowledge they could have done this in response to plaintiffs or Becker's counsel? They could have done this through their development rights. They could have set this up at the beginning. Like you acknowledge, they could have done this with a plat and showing that these things are allocated to this unit, or even reserved them themselves, correct?
Correct, as long as the timing was proper. They could have done it if it was set up in the original CC&Rs.
Then why isn't vacating this now, or saying letting a court come in and kind of set all this transaction aside long after it's done, elevating form over substance? It seems like if this could have been done one way, why would we want to upset it now?
Because of the exact legislative history that said the whole purpose of the development rights portion of the statute is to protect purchasers by providing them with warning. Because it's completely different. If I buy into a condominium and I read the CC&Rs and it tells me that there's this limited, this common element parking garage, and it tells me that the spaces are going to be allocated, I know what I'm buying. I can make a decision, an informed decision, okay, I'm fine with that or I'm not fine with that. What happened here is there's absolutely nothing in the documents to warn any purchaser that someday they would lose their walls. And that's the crucial distinction.
But you're saying they could have amended up until the time before a unit, the first purchase.
Correct, exactly.
After that time, notwithstanding, can you touch on, at least briefly, 1218, because the council seems to, opposing council seems to be relying on that quite heavily today, as far as that it authorizes, the creation the reallocation of the limited common element.
And specifically doesn't have the non-discrimination provision that's in 1217.
Yes, thank you. That's
correct. But what it does say is that 1218 says the declaration shall specify to which unit or units each limited common element is allocated. The declaration that was recorded and that people relied on when they purchased didn't specify that the walls were specifically allocated to 1708.
But that's why they did the amendment. Correct.
Correct. But
you're saying that's
the timing problem. Yeah,
Invalid.
I'm saying the amendment's invalid pursuant to not only 45 but 52, 1243 as well. All three of those things. It's invalid. And 1218 says, C, a common element not previously allocated as a limited common element shall not be so allocated except pursuant to the provisions in the declaration. Again, going back to, if you want to allocate limited common elements, you need to warn people of that in the declaration. And if you look at the declaration in this case, Your Honor, you have 3.3.1 and you have 12.4 that are both crucial. Now, the declarant did reserve over 20 development rights, for example. But what they said was, with respect to easements, is there was a development right reserved for non-exclusive easements that are necessary for construction or maintenance. That was what they reserved. In this case, it's the opposite of that. They did an exclusive easement that is not necessary for maintenance or construction. Also, if you look at section 12.4 of the CC&Rs, you will see that that one specifically says that excuse me, 12.4 specifically says that you need 80% of the unit owners, and I want to quote it to make it correct. It says that you cannot abandon, partition, subdivide, encumber, sell, or transfer common elements without a vote. That's what 12.4 says. And we know where easements fit in, because the very sentence after the one I just quoted says that the granting of easements for public utilities shall not be deemed a transfer, and you don't need a vote for that. So they reserve the right to do a public utility easement. We wouldn't have a quibble. We wouldn't have a quarrel if that was the case. But the document specifically says that for any other easements, that is considered a transfer that requires a vote of 80% of the members. And the members had a right to rely upon that when they purchased. So the final thing about the easement, Your Honor, 1220 requires that in order to, first of all, it's not an easement. I mean, from the association, the Etz court says that the court has a duty to look at what actually happened as opposed to what the party labels it. And if you look at what actually happened from the association's perspective, it's the same as if they lost fee simple. They've lost all control over this property forever. And to show what a sham this was, the only reason they called it limited common element allocation and easements is to evade the Condominium Act, which 33-1202 says you can't do. And you know it's a sham with respect to the easements because Becker calls it an easement appurtenant. They don't own any property for this easement to be appurtenant to. So it can't be an easement. Also, ARS 33-1220 specifically says that any exercise of development right must be done by an amendment. Well, if you'll notice, they didn't even do an amendment, which shows at the time they didn't even think they were exercising development rights. They're calling it that now on appeal, but they didn't even follow the process for doing development rights. Also, 1252 is important because that statute says 80% of the members must consent in writing by signing a document for a conveyance of common element. And that's exactly what happened here. The statute is clear that any proceeds go to the association and that, quote, any purported conveyance, encumbrance, sale, or other voluntary transfer is void. At the trial court, Becker's only argument was that that statute applies to the association. I agreed, saying, yes, only the association has the ability to convey the common elements. That makes sense because we bought them. Our owners bought them. On appeal, Becker's come up with this new argument to say, well, use rights are somehow different. This wasn't a conveyance. Well, if you look at Mr. Becker's deposition, he called it a conveyance. Their pleadings called it a conveyance. Their own documents that they used called it a conveyance. And there's no legal basis for saying use rights are different. But even if the court accepted their argument and said that it is different, well, then they would have violated both the provisions of the Act and the Declaration that say you can't partition the common elements. And any use must go along with ownership of the units. So they can't have it both ways. The bottom line is they either violated 1245 or they violated 1252. And if this court accepted their argument, it would render complete chaos in community associations because there would be no limit. They could literally take an elevator and say, hey, all of you guys bought thinking this elevator was a common element, but you know what, we're just going to say, we're going to call it an allocation of a limited common element now, and we're going to sell it to a third party who's going to charge you to use the elevator. That would be allowed if you ruled in favor of them. Likewise, if you accepted their argument that once I have a limited common element, I can do whatever I want with it, that would allow people to use their patios for businesses, and it would completely wreak havoc with the entire residential neighborhood or residential character of condominiums throughout the state. The other issue is 1243. 1243 says we don't care what right you have. You have to exercise it at an open meeting if there's a conflict. And the statute says it's an automatic void if you don't disclose the conflict at an open meeting. In this case, they didn't have an open meeting. They used a written consent process to avoid an open meeting. And what happened here is there was a conflict because the only two directors of the board were the very two same principals of the declarant. So they were the guys who took the money. So there absolutely was a conflict. The fact that they didn't disclose it at an open meeting triggers 1243, and that means that it's void under that statute as well. Also, 4.1 of the declaration, Your Honor, says the whole entire community is residential use. So you can't use a unit for residential use. We know that. And they're trying to use 1708 to do a commercial use. Now, they come back and say, no, we have nothing to do with a unit. We're just using common elements. Well, that begs the question, what right do they possibly have to use our common elements to operate their business? Their only response is, we have a contract, which leads me back to 1245, saying if you're going to rely on a contract, then that is voidable. The final point, Your Honor, since I've got a minute, is even if they had a technical right to do this, which I don't believe that they did, but even if they did, both this court and courts from around the country and the restatement have layered on top of that type of situation various different tests that are all set forth in my brief. For example, even if you have a technical right to amend, the amendment can't be non-uniform. It has to apply equally to all the owners. And here the amendments gave property to one owner at the expense of everybody else. The Dreamland case says that amendments must be in line with the reasonable expectations of the homeowners. The Tierra Ranchos case says that when an association has the authority to do something, it must be exercised in a way that's reasonable to the members. The McKeever case says that in order for an association member to lose common element interests, there needs to be unanimous consent. There's cases from around the country that say even when a developer has a unilateral right to do something, that will be set aside if they don't do it in a way that's fair to the membership. Thank you, Your Honor.
Thank you, counsel.
Todd Feltus on behalf of the appellant again. You know, a lot of what we just heard a lot of it's not in the record. A lot of it are factual issues that would, and what we heard was something that would be a nice summation for the jury. I mean, to the extent that that is what the trial court hinged its decision on, summary judgment was granted on this case, and it needs to be remanded to sort through the fact issues. Now, I don't think that's necessary here. First, and for a couple of reasons that I'd like to address here in the couple minutes I have left. First, the timing. Timing is just flat out wrong. It's not fixed at the time of the declaration. That was the whole point of the Condo Act. That's why the Uniform Commissioners spent 6 years developing the Condo Act. That's why the Arizona legislature considered the Condo Act for 6 years before they enacted it in 1986. And the point was, we don't want rights fixed at the time because it prohibits the flexibility that was missing. Otherwise, in common law restrictive covenant, you got to go get permission of all the property owners. That's what they're trying to avoid. That was the problem under the pre-existing horizontal property statute. But even there, under the horizontal property statute, if you take a look at the American Savings Costco case, which came out in 1985, the year before we adopted the Condo Act, it allowed the conversion of a common element into a unit reserved by the declaration, even though we didn't have the Condo Act in place. So this whole notion that it's fixed in time goes contrary to everything that was passed in the Condominium Act. And in fact, the Condominium Act was passed in large part to allow developer flexibility, that if the association's right in their theory of the case, it would take that all away and we're back in a pre-1986 regime. We've essentially overruled the legislature. Second.
But your client didn't do, your argument is, and I just want to make sure because the record is a little bit overwhelming at times.
Yes.
Didn't do an amendment to the development rights to convey this limited common element. They did this all via easement, correct?
My client did not do the amendment to the declaration. That's correct, because they were not the declarant. Yeah.
But Urban Commons did amend the declaration.
Twice.
Okay.
Yeah. So my client comes in as a third party, and all they have are and it's a good segue to where I was going. They have the use rights to use the common element for the purpose of wall signage. That's the key to an easement. It's a limited use. It can be exclusive, it can be perpetual, but it's for a particular use. And the use here was wall signs. Nobody else could use the wall for wall signs except for Becker boards. So and going through and what we talked about earlier about easements, that's been the law for, going back to the first restatement of property talks about that, and we're probably going back to merry old England on that concept.
So it's not an appurtenant easement because it's not appurtenant to any piece of property.
I disagree with that. It's absolutely appurtenant to the property.
What property is it?
Unit 1708 and the limited common element that goes with it. Certainly from Becker's standpoint, they weren't part of the property, but certainly from the grantor's side.
But doesn't it have to be tied to some ownership? It's not tied. It has nothing to do with ownership.
It absolutely does. It
Who
has
owns
something to do.
1708 now?
Unit 1708 is the association, I believe,
Okay.
but it's no different than I didn't grant the easement to SRP to run the power line through my backyard. I took my property subject to that. That's how, but they still have that easement. It's the same concept.
Then aren't we back to the problem we started with, which is if it's up to the association, they now have the statutory power to void that contract?
It gets back to which contract are we talking about. We're just talking, at most they have the power to void that one easement, and I think that easement can be voided without upsetting the transaction.
How? If the easement's voided, the easement from the association to Urban Commons, it's done.
Right.
What did your client acquire or still own?
Well, they acquired the easement from Urban Commons, which can stand on its own, and the court's going to have to look at they're going to have to look at that second easement with the intent of the parties. Urban Commons already had essentially the bundle of use sticks to the garage level walls. The easement didn't give them anything they didn't already have.
Wouldn't then, though, it seems, and not saying one way or another, however,
Yeah.
but if Urban Common, or if the association says, you know what, we're done, we're going to void this contract we have to granting the easement to Urban Commons, your client's remedy would be against Urban Commons at that point, not the association. So if they can continue to try and say, look, we bought this easement from Urban Commons, but the association's not a party to that, actually.
Well, there's still the property use right that's been recorded. You'd have to take a look at because Becker boards received an easement from Urban Commons that granted the rights to use the exterior level garages. Now, certainly it referenced back to the first easement, but the intent of the parties, and you may have, if this is where we go, you may have to remand this back down to the trial court to sort it out. But certainly the intent of the parties, and under the Powell case, we look at the parties' intent, was that Urban Commons was going to grant part of its exclusive use rights to Becker boards to use that LCE for the purpose of wall sign advertising. And I am out of time. If I could sum up real quick.
I'll give you just a minute.
Okay. In the end, the association's really left here to rely on vitriol, hyperbole, and a view property law that, quite frankly, predates the enactment of the Condo Act. It relies on false premises about the unit holder's rights in common elements, that they're fixed, and that common elements were sold. Neither of those things happened. The transactions that predated Becker Board Summit 2013 involvement in this transaction, they followed the Condo Act and followed properly reserved and exercised development rights. In Reliance, Becker Board Summit invested over $1 million based on everyone following the Condo Act. And it moved forward in a transaction that followed both the letter and the spirit of the Condo Act. The trial court erred in granting summary judgment in the association's favor. Becker Boards asked that the court reverse that judgment and direct the trial court to enter summary judgment in its favor.
Thank you, counsel. I'd like to thank you both for your briefs and your presentation today. We will take the matter under advisement, and we will issue a written ruling in due course. At this time, the court stands adjourned. Thank you.